have two hearings set for today. Is that correct?
Yes, sir, Your Honor. We have
was-
special exceptions and then summary judgments.
Summary judgments or one summary judgment?
It's one on my affirmative claims and another on their defenses. So two.
Those are both set for today?
Yes, sir.
Okay. All right. Well, then let's go ahead and proceed forward.
Thank you, Your Honor. If I may, let me see if I can do this in Teams here. All right, I might have to forego this Teams. I was trying to do a PowerPoint, but I have a problem clicking here. Oh, here.
You need to enable it. Go ahead, try again.
Okay. There we go. I think it's on. So let me start with the special exceptions, and I'm not sure. I think my screen's working there. On the special exceptions, Your Honor.
5, though.
Yes, perfect. No, that's where I want to be. Thank you, Your Honor.
Okay.
One of the special exceptions has become moot. Defendant has withdrawn what they call the comparative or contributory negligence defense. So that's no longer a problem. I still did accept to the what's called the detrimental reliance defense, just because I don't understand. I don't understand the defense, frankly. It's not a cognizable defense, and then I'm not sure how it applies under the facts that we've pled in the petition. And so I think maybe it's an element of another defense, but I'm not sure what defense that we're going for. So without going too much into it, I'm just going to ask the court to either strike it because it's not cognizable, or to allow them some time to replete if they want to, if they think they can replete it and allege it as a defense. And I don't know if Your Honor wants to give them a defendant opportunity to respond, or if I can move into the MSJs.
That's the whole special exception. So what is your response to that, Mr. Necros?
We would like the opportunity to be able to see if we can replete that.
Okay, you're going to have 7 days to replete that.
Okay, thank you.
I thank you, Your Honor. If I may proceed with the summary judgments.
Okay.
They overlap, and so that's why they were set at the same moment. There's frankly no dispute as to the elements on which liability is established, and the only claim for which I moved for summary judgment was the covenant of season. There's only two elements: that the seller did not own the property and that they conveyed the property. And then again, as you can see on the screen there, in their response, defendant actually says they agree that that's the case. Those are the facts, and that's what happened. By way of evidence, we have in the record the deed from defendant to our insured, Mr. Lieja, Louis Lieja. And so within the deed that shows the actual conveyance, and again, they've admitted that they did not own it. Defendant did not own it. And that's fully established. So the liability is just there. You know, the elements are met and the liability is established. I'm further arguing that the damages element is also established. And damage, you can grant summary judgment even if damages is a question, but here it's not a question. The Supreme Court has said that the damages for a season claim is the consideration that was paid. And there's no dispute that defendant, Mr. Lieja, or defendant, that's our insured, excuse me, that our insured paid $69,000 to defendant, and then likewise that we as the insurance company paid Mr. Lieja $69,000 for the consideration on the property. And so not only are the elements established, but also is, but so is the damages. And so I think we're ripe for summary judgment, which gets us into the defenses. And then likewise dovetails into the no evidence summary judgment that was also filed. On the no evidence, I'll start with this afternoon, about 20 minutes ago or 10 minutes ago, I filed a reply to defendant's response. In that reply, I have my written objection to the 14 pages they've attached that they're labeling as evidence. And so
when did their response get filed? Because I checked the docket last night. I didn't see it.
Their response was about 7 days ago. I want to say Monday of last week.
Okay. So it was filed on time. I didn't see it.
Yeah, but nevertheless, I'm objecting to the 14 pages they attached on the grounds that those documents are hearsay, not subject to hearsay exception, and they're unauthenticated. And so I don't think the court should consider them. And so therefore they've filed a response with no evidence. Excuse me, if I may restate that. Their response to our no evidence motion was to not submit any evidence, which establishes our motion. But even if Your Honor were to look at the 14 pages, they don't rise to the level of raising a fact question on any of the challenged issues. For fraud, we specifically challenged every single element. And their response was to point to two documents. One was the deed that went to the defendant from the prior owner, and the other was a series of text messages. However, none of those implicate Chicago Title or are insured. We were not in those emails. And so these two pieces of documents don't raise any questions on any of these elements. They basically haven't established any of the elements of fraud. The same is true for that. Well, I think they're going to replead detrimental reliance. I'm not sure if we should reserve on that until I can re-MSJ it again, or I guess we could, because it's premature to rule on it if they've admitted today that they're going to replead it. So, so I think we have everything for our MSJ on the season claim, Your Honor. We've got the elements, the damages, and then none of the defenses are going to survive to counter that. And so I reserve the rest of my time.
Okay, response.
Yes, Your Honor. We do think there's a fact issue on the damages part of the claim, because my client did not receive. She sold the property, or she paid $56,500 to another party that was involved in the transaction. This company called JDR Capital. So my client did not receive $69,000. She only received approximately $12,500. So we think damages is an issue in this case as to what amount she would be liable for.
So explain that exactly. So they did they provide the funding, or kind of?
What I think happened is that JDR Holdings had a contract with a seller, and then they wholesaled their contract to my client for $12,500, and then my client was essentially the end seller, but she didn't receive $69,000. She only received the wholesale fee, which was about approximately $12,500.
But your client was the seller, though, right?
At the end of the day, yes. Yeah.
So she might have a claim against this other entity, but
I think so. Yes.
all right. So I'll grant summary judgment on the issue. How do you say it? Season or season?
Season, I believe, Your Honor.
Season. Okay.
I can submit an order for Your Honor, and then we'll, I guess, come back to the defense of detrimental reliance once it's replayed.
Is that all we have for today?
That is all, Your Honor.
Yes.
All right. So, Mr. Torres, when you prepare the summary judgment and special exception order, I want you to include it together. So as one order, make sure that it says at the beginning that this was heard on October 2nd, 2023, that it only covers what we've actually ruled on. And it also gives so make it an order for both the summary judgment and the special exceptions in one order. Make sure you share that with Mr. Nocross, and that you get it to my office, email Rhonda, as well as e-file it no later than this Thursday.
I'll do it by end of business today if I can get Mr. Norcross to look at it.
Right. All right. Well, thank you.
Thank you, Your Honor.
Mr. Norcross, you have 12 hours to look at it. And then if you don't respond within 12 hours, then you can submit it to me.
Okay. I can look at it by the end of the day today.
Okay. Great. You guys have a great rest of your day. Okay.
Thank you, Your Honor.
Thank you.